you see the court reconstituting panels all over the courthouse. I've never seen it quite so much, but we all like it because not only do we get to see a different set of lawyers, we get to see different colleagues at the bench. So glad for that. The case that we have this morning is, what is the case we have this morning? It's Foster. Foster versus Wynne. Okay, now we've got the case right, and if we don't, say so. Mr. Bowman, glad to hear from you.
May it please the court. My name is Gary Bowman. I represent the appellants Karen Foster and Vicki Marsh. I'd like to first address four small factual issues that, reading the briefs again, are not clear from the briefs. I'm not sure how much difference they make, but still they're not clear. First is the amount of time that elapsed between the mandate from this court from the prior appeal until Foster and Marsh filed their motions to intervene. Mr. Wynne says in his briefs it was 4 months. It was not quite 4 months. It was about 3 months and 3 weeks. The second point that I want to clarify is that Mr. Wynne says in his brief that
Let me ask you this.
Yes, sir.
Let me suggest you just make those corrections when and if they become necessary to your argument. And we've read the filing of this case. Let me ask this. You do agree, don't you, that your statute of limitations is run before you move to intervene, absent equitable tolling?
Yes,
you agree with that?
Yes, sir. Just to clarify, our contention is it had not run for either
No.
prior to the district court dismissing the case initially.
Yeah, but I didn't ask you that.
Yes, sir.
But I'll take that point.
Yes, sir.
I was establishing this from my understanding, that the statute of limitations had run for both plaintiffs by the time there was a motion to intervene.
Yes, sir, that's correct.
And then there would be, I believe, some requirement of equitable tolling for you to be able to get around that block.
Yes,
correct?
sir, that's correct.
What do you propose? What are your arguments on equitable tolling? Isn't this the crux of your case?
Yes, sir, it is.
Okay.
And that's all I really wanted to talk about this morning was not waiving any other arguments.
Sure. Yeah, you made them in your brief. You don't waive them.
Yes, sir. So there are two factors under the Supreme Court's Holland versus Florida case and this court's Harris versus Hutchinson case. First is whether the interveners acted with reasonable diligence. And the factors I think that the court should look at here regarding reasonable diligence is that there's a 4-year limitations period on civil RICO, and that's the measuring stick of what diligence.
Let me stop you.
Yes, sir.
I guess the condition preceding is you don't think this appeal is moved.
No, sir.
Correct.
No, sir, because if it went back to the district court could decide to let the interveners proceed with an independent action.
Thank you.
So on reasonable diligence, there's a 4-year limitations period. That's the measuring stick of what diligence is. Absent this appeal, reversal, going the unusual circumstances of this case, Foster and Marsh would have had 4 years to bring their civil RICO case. If they brought it within the 4 years, that would be deemed reasonably diligent. If they didn't bring it within the 4 years, they blew it. Essentially here, Judge Moon said that they weren't reasonably diligent, or Marsh wasn't reasonably diligent, because she waited 3.5 years. That's true. She did wait 3.5 years.
I think you misread that. As I read the opinion, I think he doesn't limit you to 3.5 years. I don't think. I think he's just suggesting as an example of you could have done something even before then, but I don't think that. Do you think he ruled that you only had a 3.5-year statute of limitations?
No, sir, I don't think you ruled that way, and I think that you read it correctly. But the point is that taking it that way, yes, that's true. But that doesn't really mean that she's not reasonably diligent because she had 4 years. Sure, she should have, like everybody on most things that they do, should do things sooner rather than later. But she had 4 years. And so to deny her equitable tolling in these circumstances is really to take 6 months off of her 4-year clock. And that's tantamount to shortening, the way that I'm presenting it. That's tantamount to shortening her statute of limitations or her limitations period.
What were you prevented from doing during that final 6 months?
Well,
weren't there steps you could have taken?
Yes, sir. I think
and by the way, before you answer that too quickly, if there were, then doesn't that defeat your claim of equitable tolling?
Well, when I say yes, sir, I'm just saying I understand the question.
Oh, okay. And when I say, wait a minute, I didn't want you to hurt yourself in your argument, okay?
The question, that really gets at extraordinary circumstances, I think, as much as reasonable diligence. What could Foster and Marsh have done in the period after the district court dismissed CVLR's case, saying that on the precise same facts that RICO's continuity requirement had not been met?
Did you have filed a motion with the district court to protect yourself? And go, Your Honor, we know that the case has been dismissed, but we filed to protect ourselves. Could have done that, couldn't you?
I'm not aware of any type. I've never seen.
Did you try it?
No.
Could you have filed a motion to intervene in the appeal at this court?
I don't think so.
You didn't have to file a motion. You could have just filed a lawsuit, and in the lawsuit, make it clear that you were filing the lawsuit in order to protect yourself against the tolling of the running of the statute.
Yes, sir. And from this perspective, with all due respect, from the perspective of down here in Richmond, up at the bench, this case looks differently than it does from down here as a lawyer with a civil RICO case in district court. When we were here before, when Judge Shedd was on the panel.
I was a district court judge for 12 years, and I had lawyers stand up and go, Your Honor, I know you've ruled this way, but we're making this motion to protect an interest. And you know what you do as a judge? You go, I understand and thank you. Of course, your motion's denied, but at least the lawyer's taken a step, and judges understand that.
No, sir, I'm not sure they do, and that's what
they do?
That's what I want to talk about. No, sir, I don't think they do. Okay,
I think say this. Note for the record. I said judges do understand that, and you said judges don't understand what they're doing.
Yes, sir.
Okay.
And I'm saying this from the perspective, frankly, of a lawyer who has been sanctioned by district court, and I say it from the perspective of a lawyer who has defended other lawyers who have been sanctioned by district court in a civil RICO case, this particular judge in a civil RICO case against another lawyer. As we discussed when we were here before.
But that's a very broad statement. It doesn't say anything about the nature of the sanctions, the merits thereof. Are you suggesting that this judge would have sanctioned you had you gotten up in court and said, Your Honor, I know that you have ruled. The case is going to be appealed. In the meantime, the statute of limitations is running against my client, and I'm filing this lawsuit in order to protect my client's interests. Are you saying that you would have been sanctioned for that?
Okay, I'm saying that if there was a dialogue where I was in front of the judge and saying that, then that's possible that could have occurred.
Well, and then you would have appealed. And then you could have appealed the sanction and come before us, and presumably if you had filed that lawsuit in good faith, I would think that this court would have decided in your favor. I mean, and I know this is hindsight 2020.
Yes, sir. That's precisely. That's exactly the point.
But you're asking the court to invoke its equity jurisdiction. You've got to make a showing that you did something more than just sit around and wait to see how the appeal would turn out in this case.
Yes, sir. As I was saying before, when we were here last time, one of the main things that we talked about was how district courts disfavor civil RICO, and that the court opinions are basically metaphors of why you can't have a civil RICO case. Now, this was already a disfavored cause of action. The district court here, on the same facts, had already ruled that the civil RICO continuity requirement had not been met.
Maybe you should decline your client's request that you represent them. If it's a disfavored cause of action, and you're worried about what the judge might do to you, and realistically, you don't have to take a case from anybody. Just say, thank you. He's already scalped me one time. I don't care to be in front of him, or I don't. These kind of actions are disfavored. I'm not sure. To say they're disfavored doesn't mean that the court's not open to the appropriate RICO action. What did this court do on your RICO?
Yes, sir. And on the
it reinstated it, didn't it?
Yes, sir. After the district court dismissed it, we came here. It was reversed. We went back, and the case was settled. Okay, so it was a successful civil RICO case. However, in general, they're disfavored, and they were disfavored. This case was disfavored by the district court on these facts before.
And you represented the plaintiff who settled?
Yes, sir.
And these plaintiffs who trying to get into the case after the settlement?
Yes, sir. That's right. Okay. And so if we had filed realistically, I'm talking realistically, if the interveners had filed a new suit, which they could have done on their own, and met the statute of limitations, if the interveners had filed a motion to intervene in this dismissed case, there wasn't a case, it was dismissed, so there was nothing to intervene in. Okay, whether they could have intervened in this appeal, I don't know.
A district court keeps certain ancillary jurisdiction after a case is appealed. Sure it does. It's not, a district court is not foreclosed from each and every matter in a case that has been appealed. That's the law.
It would have been foolhardy, realistically. It would have been foolhardy to go right back to the district court after the district court had erroneously dismissed this case and tried to intervene. Now, I understand there are all kinds of things that can be said. Realistically, that's foolhardy.
You could have filed another lawsuit, couldn't you?
Yes, sir. And as I said, that would have been foolhardy as well because the district court, this same court, had already said that RICO's continuity requirement had not been met.
Could you file that in state court?
Well, they would have removed it, Your Honor.
But you could have filed that lawsuit, and if it was removed, you still would have taken a step within the statute of limitations.
Well, Your Honor, they would. Yes, the case could have been filed in state court, as far as I know, standing here. But they would have.
Answer you said to Judge Shedd's question. That is, that if you had filed the lawsuit, it would have been foolhardy to go back to the district court. But had you done so, you would then appeal to us, and the issue of the statute of limitations would not be what you'd be arguing.
Well, the prudent thing that my learned opponent would have done is he would have filed an answer, he would have removed the case from state court to district court, and he would have filed a motion for sanctions. Now, this dialogue that the court here visualizes would occur, that's not how the motion for sanctions work. They have to send a 21-day letter, in which case you withdraw the case. If we withdrew the case, then that vitiates the argument that we're making here.
No, it doesn't. You could then say, I asked for equitable tolling because I tried to do something. I filed something, but the court threatened my professional standing, the other side in the court. And so I was sort of given a Hobson's choice, and I didn't want to be sanctioned, but I took a step to take action within the statute of limitations. Don't you think you would be on considerably stronger ground had that occurred?
No, sir. Again, realistically, I live out here where this happens, and realistically, that is not what would have occurred. Okay, now,
what would have occurred is you would now be in front of us on some kind of appeal or something going, I tried for my clients. I took an action within the statute of limitations period. I took it. Maybe it wasn't the right one, Your Honor, but I did something to get a matter called to the attention of the other side before the statute of limitations period ran. That's real world.
And this is not what I would do. Okay, now, that's not something that I was prepared to do as the lawyer. Now, could the clients have gotten someone else to do it? Maybe, but not really. They couldn't because of the complexity of the case, because of the posture of the case. The district court had already dismissed it. They couldn't have realistically gotten another lawyer. Now, the standards here on equitable tolling are, were they reasonably diligent? Not all possible diligence. The Supreme Court said in Holland versus Florida, it is not all possible diligence. It's reasonable diligence. Now, here, there was 6 months taken off the clock because the district court erroneously dismissed the case. This court then reversed it, and in terms of their statute of limitations.
After this court reversed it, how long did it take you to act?
It took 3 months and 3 weeks. That was the factual thing that I said at the beginning of my argument.
So why? Why didn't you do it earlier?
That's as fast as it could be done. Now, in terms of reasonable diligence, given the complexity of this case, that's reasonable. One could say it's not reasonable, certainly, but that was as fast as it could be done. In terms of the extraordinary circumstances, which is the second part of this test, Okay, this is a case of first impression. Okay, this hasn't happened before. It's an unusual and extraordinary circumstance. Now, the only things that would vitiate or that would have satisfied these extraordinary circumstances is they could have filed their case sooner. Yes, they could have, but their measuring stick was the 4-year limitations period. What they could have done is they could have filed some action in court, and frankly, it would be in the district court, because if it's a RICO action, it's going to get removed or it's otherwise going to get to the district court. They could have taken some action into the teeth of the district court after the district court had already dismissed this.
In the appeal. Why couldn't they have moved to intervene in the appeal? And let me tell you this much. You might be denied, but then you would have taken some action, and we'd be arguing about that you didn't take any action was the action you took to defend your client's position enough?
Well, my time is out, but if I could just answer that briefly. The appellee has not raised that argument about the intervention on the appeal. And frankly, standing here, it sounds to me like that's not something that could be done. But of course, I haven't researched it. I don't really know whether that could be done. But I don't see how a party who had not moved to intervene in the district court could then move to intervene in the appeal in these circumstances.
Okay. They file a motion with the court, moving to intervene. But that's how they would do it. But you've saved 5 minutes.
Yes, sir.
You saved 5 minutes. Thank you very much, Mr. Mooney.
May it please the court, Chad Mooney on behalf of the appellees. We believe that the trial court's decision to deny the motions to intervene should be affirmed for 3 reasons. The first of which...
So you think it's not moot?
Oh, we believe that the appeal is moot, given that the underlying case has been dismissed.
Do you want to argue that first? Do we have jurisdiction to hear this case? Is this matter a motion of intervention? Is it moot? Yes or no is what I'm asking. Do you think it's moot?
Yes, Your Honor. Since the filing of the appeal, the underlying case has been dismissed. And
but just let me ask you this. I asked you to set you up so I could ask this question. Don't we have to have the right to review a motion to keep a judgment of the court to keep somebody out of a case? Don't we have to have a right to review that?
Yes, you do have the right to review it, but there's jurisdiction and there's precedent that establishes that once that underlying case has been dismissed, the issue to intervene is moot.
I know that, but I'm saying I understand that. But don't we aren't bound by any precedent you cite that we can't hear this case, are we?
I still think the court can hear the case. Okay. I think it's not dispositive of taking the appeal, but I think it moots the motion.
All right, let me just. Do you think the question of the motion itself and the merits of the motion and the statute of limitation, is that fairly in front of us for a decision at this point?
I don't think so, Your Honor.
Okay, that's what I was asking you. But now the second question is, but I'm asking you this, don't we as an appellate court have to have some opportunity to review a denied motion to intervene, at least in some circumstances, don't we?
Sure.
Okay, so we do, but this is just not the right circumstances.
That's correct.
Why is that so?
Well,
distinguish the two types. When would it be appropriate and when wouldn't it be appropriate for us to get beyond your mootness argument?
Well, I don't think it's appropriate in this particular circumstance because what appellants are actually asking the court to do is to send the case back or to overturn or
we know what
and send it back.
No, we know what they're asking to do. You don't. I said distinguish for me when you think the issue wouldn't be moot and when the issue is moot. Now you've told me you think these facts make it moot. What kind of motion to intervene denied in a case that's then settled, dismissed, or decided? When would that not be appropriate for us to look at?
Well, I think it would.
Or when would it be appropriate?
I think it would be appropriate if the case was still open. No. But the case, every case is settled or ended generally before it gets to us. I don't understand that. Let me ask you this much. Do you think, I still can't get an answer from you. I'm trying to decide what you think
when would it be appropriate for us to review a denied motion to intervene when after that motion the case is dismissed or settled?
Well,
when would it be appropriate?
I guess I don't have the answer for you here today.
So you think it's never appropriate?
I'm not saying whether it's always appropriate or it's never appropriate. I don't think I have the answer for you today.
Okay.
What's your best case then? I mean, you rely on this Chesapeake Bay Foundation case that we decided, but that case is distinguishable because the intervener in that case essentially conceded that the settlement gave it all of the relief that it would otherwise have sought had it been allowed to intervene. That's not the case here. These plaintiffs are entitled, if we agree with them, they haven't been made whole, and they're entitled to their own relief if they can get it.
Well, I don't think the Chesapeake Bay case went so far as to say that the plaintiffs were entitled to the same exact relief. I think that was kind of vague on that particular point. As the appellants point out, that the plaintiff's cause of action is independent of the intervener's cause of action, and we acknowledge that fact. But we think the rub of the Chesapeake case is that once that underlying case is dismissed, that moots the motion to intervene because there's no...
The problem you've got is, as Judge Shedd has alluded to, is if the underlying case is dismissed and then they seek to intervene, that's a different scenario than what you have here. You have an active case. The parties seek to intervene, and it's denied. And then by the actions of others, they settle it. They're not party to it, and they can't vindicate their rights now because they've settled it. But they made the motion during the cause. I think we can appreciate your argument, but you might want to move on at this point.
Sure, I'd be happy to, Your Honor. The second point that we address in our brief is the fact that the equitable tolling doctrine was properly denied
Why
in
so?
the district court. Is
Why?
Because both Marsh and Foster failed to demonstrate that they diligently pursued their rights in the federal district court by the active pursuit of filing a lawsuit. As the court has already noted, that this was a circumstance where you had 3 women who have alleged predicate acts against Mr. Wynne and his related entities. And this was clearly a close relationship between these 3 women, and there was obviously some discussion among these 3 women because when Marsh had filed her lawsuit, when CVLR had filed the lawsuit on November 30th, 2011, it alleged predicate acts along with Marsh and Foster. So it had been very easy for Marsh and Foster to essentially piggyback on that lawsuit, but rather they adopted a wait-and-see strategy. It's like a train moving down the track. They're waiting to see if that train derails or if there's some sort of settlement so that they can hop on shortly before the station. And that's exactly what they did in this particular situation. They waited Marsh herself waited nearly 7 years to file something remotely similar to a RICO action.
If they had filed that, would you have moved for sanctions?
Well, Your Honor, it's very similar to the appeal of the CVLR case. We did not move for sanctions in the CVLR case. That case is no more, Marsh and Foster's case is no more sanctionable than CVLR's appeal of the district court decision. You have the same standard that an attorney has when filing a brief, and Rule 11B essentially states that you can ask for a good faith modification or reversal of the law. We did not ask for sanctions in the CVLR case when it appealed the district court's decision. I can't say because there's nothing in the record saying that whether we did or would not ask for sanctions in the second case, but those 2 cases would be similarly situated. The appropriate course of action would have been to intervene prior to the appeal and then taking the appeal up together, or shortly after this circuit court's reversal of the district court's decision, whether you believe it was 3.5 months to 6 months, at some point in that time there could have been a filing much earlier. But again, there was no demonstration of diligence for 7 years prior to that, or 5.5 years prior to the district court's dismissal, or the 3.5 to 6 months after the reversal. And so
have you ever experienced in your practice when a lawyer makes a motion, knowing that on the current law, the lawyer is going to lose, but you just explain to the court that you have to make that motion to protect some interest?
Absolutely. And, sometimes you go before the court, you're sheepish, and you say, apologize, Your Honor, for doing this. This is the course of action that I have to take to protect.
Just let me say, as a general rule, you should always be sheepish when you come before judges. But I've seen it just as a district court judge. I'll just say this and ask if you've seen it. Defense lawyers would stand up and go, Your Honor, I move that document can't come in. I know, Your Honor, that under current law in the Fourth Circuit, that document can come in, but I make that motion because I want to preserve that issue so that I may argue it. And you go, okay, your motion is overruled, but judges understand that.
And I think, Your Honors, you can look behind the reasons that the lawsuit was not filed sooner. They were clearly adopting a wait-and-see strategy, and that's not the purpose for the application of the equitable tolling doctrine. The case law is pretty clear that it's usually for circumstances outside of one's control, and they clearly had the control and ability to file the lawsuit. They just chose to file it later.
Well, even if we don't agree with you that they were waiting a wait-and-see strategy, the fact of the matter is they could have taken the action that you propose, and whether it was for benign reasons or they just weren't counting correctly, that doesn't matter in this case, does it?
No, we don't. I don't think it matters. I mean, they had every opportunity. I mean, they knew this suit was going on, and there was clearly some communication. They knew that by apparent discussions with the plaintiff in the underlying case, they knew this case was ongoing. They could have easily filed.
What do you make of the contention that at least one of these plaintiffs was suffering from a disability that may have influenced her ability to actually protect her rights?
Well, if you look at the motion to intervene, Marsh alleges that she suffers from autism. The point of the reference to autism was simply in the context of explaining how she was allegedly defrauded by Wynne. It was not proffered for the reason to establish that was the reason that precluded a timely filing. And this is the first time that I've heard about this issue is on appeal, and it's an issue and a tactic of essentially Monday morning quarterbacking, scouring the record to see if there's any other issues that they can raise on appeal. And I think this circuit in United States versus Muth has decided that issues heard for the first time on appeal cannot be considered. And there was nothing in the record to establish, no affidavit establishing that she actually suffers from autism. Marsh didn't support that factual statement. We have no doctor's reports. We have no medical evidence to determine or to submit that she has autism. So we don't even know. We're essentially speculating.
What is our review that you maintain from this denial of intervention based upon the fact that the court says that you're not entitled to equitable tolling of a statute of limitations that's barred?
I think it falls under the abuse of discretion. Is that what you're asking?
So the issue is whether the trial court abused his discretion in determining that there was not due diligence to support equitable tolling.
That's correct, Your Honor.
And the basis of that would be, speak to the due diligence, because that's really the heart of this case, at least from the equitable tolling. The plaintiffs here contend they did exercise due diligence, and to the extent they didn't, it would have been essentially futile to take those steps of filing a complaint, or because it was going over. And so the court essentially abuses discretion.
Well, we don't think that this case is just limited to the due diligence prong. We also think that there is an absence of extraordinary circumstances. But to answer...
So you're hanging your head on
both. And the district court found that there was the existence of neither. But if what Marsh and Foster are trying to do is not... There's two components that I see on the diligence prong. It's what actions did you take and how quickly did you take them. if you look at Marsh and Foster, they didn't do anything. Their actions, they didn't do anything in terms of trying to file a lawsuit. Marsh points to complaining to state and federal authorities. Foster points to actions she took in her bankruptcy court and challenged the foreclosure of her property in the city of Lynchburg. So if you look at just what they did, there was nothing remotely similar to filing a RICO action. But then you also have to look at the time component, that they took a long amount of time to finally move to intervene in the case. Turning next to the extraordinary circumstances, the appellants point to the district court's dismissal from that time until this court's reversal, that constituted extraordinary circumstances. And I ask this court to focus not on how unusual the circumstances are, but the severity of the obstacle that would preclude the filing. And again, under extraordinary circumstances, you typically focus on the conduct of the part of the defendant, or for circumstances beyond plaintiff's control. And what they are asking this court to do is to basically apply a different standard, because they're saying that if we shift it away from, let me back up a minute. We cited two cases.
Why don't you just apply the standards you think apply to this case and tell us what the result?
Well, we think they're arguing essentially that it's an unsettled area of the law or uncertainty of the validity of their claim. And there's circuit court decisions out of the Second and Seventh Circuit, or the Third and Seventh Circuit, that demonstrate that the uncertainty surrounding an area of law is not sufficient to constitute extraordinary circumstances. And that's essentially what they're arguing here today. And so that really shifts the control of filing one's case to the appellants, because then they can come up with any conceivable argument to cast doubt on the validity of their claim. And so basically you're switching the circumstances from outside of one's control to control of the appellants. And we don't think that's proper. It's a flawed standard, and the equitable tolling doctrine is to be reserved for individual hardships. It's not to be applied liberally, and it's only to be reserved for the most rare circumstances. The last point of our argument is that the equitable tolling doctrine does not apply when extraordinary circumstances occur after the limitation period has run. You heard from opposing counsel that the 4-year statute of limitation applies in RICO actions. If we have a limitation period that ends after 4 years of the date of injury, if you have an extraordinary circumstance that occurs 20, 50 years down the road, well, that did nothing to preclude a timely filing. And that's what we have here in this particular case, is from the date of injury, more than 5 years have passed.
What do you, if the extraordinary circumstances is the erroneous dismissal of the action, are you maintaining that's when the trial court made the determination or when the appellate court made the determination?
According to the appellants, they're saying from the time the district court erroneously dismissed CVLR's RICO action all the way until this court reversed the district court's decision. So it's that length of time that creates the extraordinary circumstance, and that they were precluded from filing during that period. But if you look at when the district court erroneously made its decision, that was already anywhere from 5 to 5.5 years after the appellants first suffered any injury.
But does it come from injury or discovery of injury?
Well, it's the discovery of injury. But they knew earlier, Marsh, for instance...
Is that argument necessary for you to win this case? That they knew for 5 years? Is that argument necessary?
It's not necessary for us to win this case, but it demonstrates that there's more than one grounds that the appellant's brief or appeal can be denied. Again, we believe that, in a conclusion, we believe that the district court's decision to deny the motions to intervene was proper because the equitable tolling doctrine did not apply for two reasons, as I just stated. They failed to demonstrate that they exercised due diligence in actively pursuing the RICO claim, and that two extraordinary circumstances did not exist. Thank you, Your Honor.
I have one last question on the standard review, and that is, do you maintain that any of the facts in here are in dispute?
No, Your Honor. It's how we interpret those facts. If, according to the appellants, they point to facts that occurred much later that would alter the running of the limitation period. But as far as the facts that were alleged, the court, I believe, looked at those facts in the light most favorable to the plaintiff or the appellants when they ruled. Thank you, Your Honor.
Thank you. Mr. Bowman?
The court asked Mr. Mooney, when should review be allowed in circumstances like this? This equitable tolling jurisprudence really focuses, and the Supreme Court said in Holland versus Florida, it focuses on the particular case. I'm not arguing for a rule. I'm not even arguing for a precedent. I'm saying in this particular case, these are weird facts, and my clients were harmed on these strange facts.
That the standard of review is abuse of discretion?
Yes, sir. It's abuse of discretion. And the rule should be applied here because my clients moved to intervene before the case was ended at the district court. Their motion to intervene was pending. Then there was an appeal out of the case. So they had intervened before the case ended. Now, my clients had 4 years under the statute of limitations. Mr. Mooney argues the statute of limitations had already expired. The district court didn't buy that. They had 4 years. Okay, because the district court erred. Wasn't our fault. It was fair game for the district court. It happens. They erred. Because the district court erred, 6 months were taken off Ms. Foster's and Mrs. Marsh's clock. Then this court stepped in and reversed the district court's error.
Their clock to do what?
Their clock to intervene. Now, what this case comes down to, I think, based on the oral argument and based on the briefs, what it comes down to is, should they have done something? Okay, did they do nothing to the extent that they're not entitled to equitable tolling? Now, that's simply, I think, a matter of judgment, of course. But our argument is that in these circumstances, what they did was reasonable. The district court, the very court.
What they did was nothing. So you think it was reasonable?
That's not exactly true that it was nothing. If you look at the facts.
What did they do as far as any type of notice, a court notice to the other side? What did they actually do?
Okay, well, in Ms. Foster's case, okay, if you look at the facts, which is not something we've talked about here, but it's in the briefs, Ms. Foster had filed bankruptcy. And that bankruptcy, she had listed a RICO claim, and the bankruptcy case was pending at the time the district court dismissed the case. Now, remember, she still had 6 months on her clock. She had said in her bankruptcy schedule she had a RICO claim. It's unreasonable to assume that if she didn't have that 6 months, she wouldn't have filed the RICO case. Now, that gets back to, well, she should have filed it earlier. Okay, she should have filed it earlier, but she had another 6 months. So she didn't know she was going to get cut off. And also in terms of...
She had 6 months to do what?
To file a RICO case. She had 6 more months to file the RICO case, but the district court said that this is not a viable RICO scenario, and so she couldn't file the RICO case in our estimation because the district court said that these facts, Mr. Wynne's actions, didn't constitute a viable RICO scenario. Now, in hindsight, and it's strictly in hindsight to use Judge Diaz's words, in hindsight, it appears now that she could have gone, Ms. Marsh, Ms. Foster, could have gone into district court and filed some paper and sheepishly say, oh, we're filing this.
The parties hadn't appealed that dismissal from the district court.
Pardon?
What if that erroneous dismissal had not been appealed?
It was.
What if it hadn't been?
Then they could.
And you waited beyond 6 months.
Then they would be out of luck, I think.
So you are reliant upon them appealing this matter. in order to protect your rights?
This is an unusual circumstance. Okay, when the district court said that the RICO continuity requirement had not been satisfied on these facts, prospectively at that time, you assume the district court is right, and prospectively even you assume odds are that's going to get affirmed up here. Okay, and so Ms. Foster and Ms. Marsh could have then filed another RICO case, filed their own RICO case, even though the district court had just said this is not a scenario for a RICO case.
But when you got a statute of limitations out there, and you got an action that's pending there, and you know that action potentially can decide issues that will affect you, and you choose to wait until a period of time occurs when the district court says there's no action. I mean, how does that it seems like diligence has to be considered in that light.
Let's look at
your fate is in the hands of someone else the whole time. You wait. How long did you wait? How long had that other action been out there?
She has 4 years.
I understand that, but how long had the other action that affected your action been there?
About 6 months.
And all on that time, you just waited until it was dismissed, and then you waited until the appeal reversed it. And then you come in, and then you waited there. You said you had to wait 3.5 months later to file it. But then you bring an action, and you're beyond the statute of limitations. He says equitable tolling.
Yes, sir. My time is up. But
you can answer that if you want to answer that.
The reason why these people were entitled to equitable tolling is because if they had done something in the last 6 months, I don't think certainly they could have done something in the first 6 months, in the first year of their limitations period. They had 4 years. Okay, I don't think that it's frankly fair to say they should.
Let me just say this, but you have to answer the question.
Okay.
It's not unlimited time.
Okay. And so to say that they did nothing in that last 6 months of the limitations period when they could have, that's true, except the extraordinary circumstances here was that this district court had said on these facts that that was not a viable claim. So either those people can go straight into the teeth of the district court that had just said this case is not viable, or they could wait to see if the Court of Appeals said it was viable and then seek to intervene. And if the court said it wasn't viable, then that was the end of the story. Okay, but the district court's error and this court's 15.5 months of deciding it, which are not, district court's not, out of bounds. I'm not saying that it was wrong,
Just let me have you finish up in
Yes,
another
sir.
10 seconds.
Yes, sir. All I'm saying is that this is an extraordinary and unusual case, the type of case that the equitable tolling doctrine exists to cure.
Okay. Thank you very much. We'll recess and then step down and greet the lawyers.